I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first segment in a multi-part Lawcast discussing mergers and acquisitions. My firm is constantly working on a merger or acquisition transaction or reverse merger transaction. Earlier this year, I did a multi-part Lawcast series on reverse mergers. Today is the first in a series on mergers and acquisitions. I'll begin the series with discussions on the responsibilities of the board of directors and in particular their fiduciary duties related to merger and acquisition transactions. Under state corporate law, the business and affairs of a corporation are managed under the direction of the board of directors. Members of the board of directors have a fiduciary relationship to the corporation, which requires that they act in the best interests of the corporation as opposed to their own best interest. In all matters, directors' fiduciary duties to a corporation include honesty and good faith, as well as the duty of care, duty of loyalty, and duty of disclosure. The duty of care requires the directors to perform their duty with the same care a reasonable person would use to further the best interest of the corporation, and to exercise good faith under the facts and circumstances related to that particular transaction and that particular corporation. The duty of loyalty requires that there be no conflict between duty and self-interest. The duty of disclosure requires that the directors provide complete and materially accurate information to a corporation, including, of course, any conflicts of interest. Generally, a court will not second-guess directors' decisions as long as the board has conducted an appropriate process in reaching its decision. I stress the word process because it is the process that ultimately will determine whether the board has met its fiduciary responsibilities. This is referred to as the business judgment rule. The business judgment rule creates a rebuttable presumption that in making a business decision, the directors of a corporation acted on an informed basis, in good faith, and in the honest belief that the action taken was in the best interests of the company. In certain instances, such as in a merger or acquisition transaction, a board of directors naturally faces a conflict of interest, i.e., get the most money for the corporation and its shareholders versus job security and money for the board of directors. And as such, their actions face a higher level of scrutiny. This is referred to as the enhanced scrutiny business judgment rule and stems from the Unicall and Revlon cases, which I will discuss in later series of this Lawcast series. There is also a third and even higher standard for directors called the entire fairness standard. The entire fairness standard is triggered when the directors or shareholders are on both sides of the transaction, such as when the director has an ownership interest in the company being acquired or sold to. Under the entire fairness standard, the directors must establish that the entire transaction is fair to the shareholders, including both the process and dealings and the price and terms. In the next Lawcast in this series, I will continue to discuss the general duties of the board of directors in a merger or acquisition transaction, including consideration of whether the company is on the buy side or the sell side of the transaction. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.